As we get started today, I want to welcome everybody. I am super excited, for those of you who know me, that we are actually getting together. I've been waiting so long for this, and I'm hoping that those of you that are on your screens, that next month I'm going to see you right here. What you're doing is absolutely great, but I would love to see your faces. We are really excited, super excited about our topic today. Being smart about going from we to me. I think you're really going to enjoy our seminar today. So thank you so much for coming. Keeping in mind a couple of things, we have a lot of information today. And I want to make sure that you don't get too concerned about, oh my gosh, I can't write all that down. Because Debbie has put together, our Debbie, and I'll be introducing her more again in a moment for those of you that don't know her. But she's taken the time to put together a very detailed list of the topics that we're going to be discussing today. And it's actually set to go out to your emails. What time?
4 p.m.
At 4 p.m. So don't worry, because you are going to have something. Not preventing you from taking notes, but I want you to know that we felt this was a really important topic. So we have taken the time to make sure that you've got what you need to answer those, to look up those topics and questions. So this is just a brief assignment for those of you that are, especially for you for the first time. You want to make sure that you are in the mode on your screen that's unmuted, or excuse me, muted, because we want to make sure that during our presentation today that we have your full attention. And sometimes when your microphone's open, you may have dogs barking, having a conversation with something, or something going on, and it overflows into the seminar. And also because we're recording the seminar, because we want to be able to send it out to you afterwards. So we want you to stay unmuted. Also on your screen, you're going to notice that there is a black box there that says speaker gallery, show non-video participants. You want to be today in speaker view. That way you'll be able to see the panelists that we have today versus what I like to call family squares or multiple squares on the screen. We want to be able to see the panel. And then today, for those of you that are Zooming, when we get to the Q&A, because we have planned to do that today, we'll make sure and set it up so that we can see you as you're talking to us, since you're not here in the room. But we do have some people with us today, and I'm so glad that they came to our seminar. We're going to enjoy the seminar together, and thank you again for spending time with us this afternoon. I might need you here. Okay. Something else for those of you that are Zooming, for those of you that are Zooming today, just keep in mind that if you have some questions that come up during the seminar, we do plan to address those. But for right now, we're going to ask you to go ahead and type those in the chat. And then at the end of our seminar today, Debbie will go ahead and give us those questions that you have before we open up the mics. So this is our team that is with us today. We are Sullivan & Sullivan Real Estate, and we are the owners of a company called Senior Downsizing Experts. We built that company about 10 years ago when our parents were aging, and we knew that there were lots of different things that our parents needed as they were making changes from living in their own home and for them moving into a retirement community. So I have myself, for those of you that don't know me, I'm Ingrid Sullivan. I am a realtor on my team, and I'm also a right-sizing expert. We have John Sullivan. John, for those of us that are here, this is my partner in business and my partner in life. John is also a real estate agent and works very closely with us and our clients. And then the person that's actually running the Zoom for us today is our operations manager, and this is Debbie Ford in the back. And Debbie's the one that sends you out the invites from Evite. She's also the person that makes sure that you get all the materials that you need for the seminar, sends you the recording, all of those things. So she's a very important role in our business. Our mission, which is really important to us, so we want to make sure that you know where our minds are, where our mindset is when we're doing our business on a daily basis. Our mission is to empower our clients and their families to make informed choices. That's why we put the seminars together. We find that there's a lot of good information that not everybody gets access to, which is the reason that we bring our experts in. Though that information allows our friends and our families to have peace of mind, confidence, security, and an uplifting experience when they're thinking about right-sizing or making some important changes in their lives. So we want to make sure that you know that we've got lots of different things that we do. We are real estate agents, we do move management, and we also do education, which is why you're here today for the Smart Senior Series. This is a slide that talks about all of our sponsors. And what I want you to know about that is that we couldn't do this type of an event without the sponsors that are behind us and believe in our mission and passion to serve you. We have Civitas is one of our senior living communities. They have 17 different communities. They are one of our sponsors. We have Haber Wealth Management is another one of our sponsors. We have the Watermark in Fort Worth that was formerly Brookdale, Broadway City View, but now they're the Watermark, beautiful community. We have Count It All Joy Estate Sales, Old Republic Title, The Elements. We have Celebration Magazine, which we really enjoyed working with them. By the way, Count It All Joy Estate Sales, they've been really incremental for us because a lot of times when our clients are making changes, they need to deal with all their stuff, which we'll talk more about in another seminar. Cherry Creek Mortgage has been a great partner. They offer all kinds of tools, refinances, home equity conversion, mortgages in general. Great, great people to work with. And then we have Alvin Keller Ranch. And Alvin Keller Ranch is a new, what we call 55 plus retirement community. And what they offer is they have apartments, senior living apartments that are brand new. As a matter of fact, their opening day, is April 16th. So if you're curious about that, be sure to ask us some questions about it. We can sure help you to understand that. We have a celebrity sponsor today, and that is Miss Bertha Hurels. She's with Dignity Memorial, and we're going to give her a minute to tell her a little bit about her company, and she's also one of our panelists.
Yes, hi, my name is Bertha Hurels, and I represent Dignity Memorial, and I hold a license with the state of Texas. Here in the DFW area, we have 33 locations, but over 24 locations in North America, the Canadian Providence, as well as Puerto Rico. So I am here today to just try to give you some general information about the importance of pre-planning. So I look forward to answering any questions you may have. Thank you.
Thank you, appreciate that. We'll be sharing some information, and she'll be sharing some information with you as well during our presentation today.
We need to make sure that they're using microphones so they can't hear them. So,
I'm sorry?
you need to make sure they're using the microphone.
Okay, be sure to use the microphone so that everybody can hear you well. Hopefully you can hear me.
They said they're not hearing Ingrid either.
Okay, all right, well, you're going to hear me now. Okay, let's go ahead and move forward then. So let's get our presentation started. We have, actually, I want to just back up for a minute because we do have our guest today. And our guests, which I will introduce in a moment, our guests are going to be, our guest panelists are going to be helping us with our presentation today. Each one has a different part. This presentation is called Going From We to Me. And what I want to share with you about that, I belong to a group of real estate agents across the country. There's about 200 of us. And we specialize in senior housing and senior services. And this we have a conference every year in October. And this topic is one that comes up a lot between in our conversations because things like this we don't plan for all the time. You know, as it says here in the slide, the inevitable truth that the most of us will eventually face. You know, if we still have our significant other with us, We enjoy the daily living and the ups and downs of living as well. I can say that for John and I. The character building moments that we have with our significant other, and we don't really think about what's next. And we want to talk more about that today. We want to, as I would like to say, deep dive into that a little bit more than we have in previous seminars. It's important to have those conversations. Think of it this way. After the year that we just came off of, there was a lot of surprises, would you agree? For a lot of us that we weren't really planning on. So we need to take that as a lesson that it's time to make sure that we have the important things in place and in order. We want to do it while we're healthy and we're feeling good. We want to make sure that the survivors do better when losing a spouse if they haven't planned ahead as a couple. That's really important that we do that, especially, like I said, what we've just are coming out of with the COVID. It's also important not to get blindsided. You know, working together to make sure that you're both prepared, as we want to talk about today. You may think that you've got a pretty good idea about what your spouse was thinking and vice versa, but it might be a good time just to have those conversations and make sure that we're all on the same page. This is a really important statement, and Lorne will talk more about that, but this statement says the only people who win when a family fights over an estate are the attorneys.
Yes. Right.
Yeah, as he says, yes. So, you know, a good estate plan can help you prevent disputes. And for those of you that are with us today and maybe have followed us in the past, John and I have both experienced that over the last 2 years. We have both lost our mothers. And in my particular case with my siblings, there was a little bit of this going on because we all didn't know what we thought we knew about how they were planning. So it's important to try to avoid those things. Today with us, we have guest panelists, and we're very excited for them to be with you today. We have Lorne Book with Book Law Firm. We have Troy Miller with Haber Wealth Management. And we have Ms. Bertha Hurels with Pre-Planning Advisor, Dignity Memorial. And what I'd like to do is just have you all just take a minute and introduce yourselves to our audience.
Thanks, Ingrid. Hi, everybody. How are you? My name is Lorne Book. I am an estate planning and probate and elder law attorney with Book Law Firm here in Carrollton, Texas. This is my first time to actually present as a part of the senior series, and very, very happy to be here. My practice focuses on estate planning needs and probate needs. We recently launched Book Elder Care Law to provide for some of the more sophisticated planning needs of our retired clients. And so very happy to be here talking about a very important topic, how we go from two of us back down to one of us. And so looking forward to having a great conversation, answering any questions that may come up. And thank you so much for having me. This place is beautiful.
It is beautiful.
Yeah,
It really is.
So great to be here.
Hi, my name is Bertha Hurels, and I'm with Dignity Memorial, and I hold a license with the state of Texas, and I plan funerals, cremation, and cemetery property. And my role here today is to kind of give you a brief synopsis of what's involved in really pre-planning. And I would like to make it real clear for you, and that you can ask me any questions that you may have. Again, we have 33 locations in the DFW area. You may have heard of maybe Lorne, Dallas, Lorne, Fort Worth, Blue Bonnet Hills, Sparkle Hillcrest. So we have an array. And then we have over 2,400, I'm sorry, in the North America area, including the Canadian Province as well as Puerto Rico. So I look forward to speaking with you more today. Thank you.
I'm Troy Miller with Haber Wealth Management, and obviously when you're going through financial planning, there's a good chance that me or myself, or Tricia, I should say, the founder of Haber Wealth Management, would work with somebody like Lorne, a estate planning attorney. So we certainly look forward to today's topic and look forward to helping you guys and being of any assistance.
Thank you.
And yes, this place is pretty.
It is nice. Pretty, isn't it? I'm overlooking the lake. It's really a beautiful development. A master plan community, as they call it here at the Viridian. So the first thing that we would like to do together as we get started is to think about some things that are going to be important to us as far as working together with our significant other. We want to be honest with each other. That's really important that we do that. We want to look at what we have in common and things that we can do better together. We have actually asked our panelists to give us 10 questions. This is how we form our seminars. We would like for them to give us 10 questions that come up for them on a regular basis with their clients. Together, we will then take those questions to create our seminar today. So what we've done is I've got some questions that I'm going to be asking our panelists. Some of these things, more than one will weigh in on the topic. Other things we're going to be asking of one person. But what I'm going to start out with today is I'd like to start out here by just giving you some food for thought, something really important to keep in mind. When we're talking about things that we're going to do as a we want to make sure that we are looking at documents. Now, in the very first seminar that we had this year, Be Smart About Planning for Your Future, we talked about those important documents. But now we're going to take, as I mentioned earlier, we're going to take a deeper dive into, well, what are those documents? Everyone here should have a handout. You should all have a pen. There should be a place inside there if you decide that you want to make some notes, those of you that are here live today. So I want to make sure that you know that too. As a realtor, one of the things for me personally that I get involved in many times throughout the year when I'm doing a real estate transaction is something that's called a power of attorney. And in my case, a power of attorney is a document that will allow another member of the family to sign documents that would be for the sale of a property in the event that someone else couldn't do it. For example, if John was unable to, whether he was in the hospital, if he had surgery or something else, he was not able to perform his part of it, I would want a durable power of attorney so that I could actually do that legally on his behalf in the event that he could not do it by himself. But what I want to do here is I'd like to ask some questions of Lorne first. You know, Lorne, what are some of the pitfalls of using a power of attorney?
Sure. So just to reframe kind of what we're talking about the use of a legal instrument we call a power of attorney, legal instrument that allows another person to step into your shoes and bind you by signature legally across a whole bunch of different, what we would call financial transactions. So you illustrated one in the real estate context. And what I often, when I'm setting this up for clients, I will often illustrate that, you know, husband and wife, when you all went to purchase that home, you likely showed up to the title company. They handed you 2 pens and a stack of paper about yay tall, and off you went, just signing your life away, the 2 of you. Well, how would a transaction with that same house take place? Say you needed to sell it. Let's say that one of the spouses were to become ill, and that home had to be sold in order to cover medical bills, for example. Well, we have one spouse that's well, we have one spouse that's ill. How does that transaction get closed when 2 people showed up and did the purchase? Well, through the power of attorney is the instrument that would allow that to happen. And it doesn't have to be a family member, it often is. Specifically with married couples, it's often husband executing one in favor of wife and vice versa. But the strength of that power of attorney would allow, say, the wife to show up and execute those documents using her signature on her part and signing for the ill spouse in his part and legally bind him to that transaction and close the sale. So that's kind of just the frame that we're using. But there are a number of different pitfalls. And I would say that, you know, one of the biggest pitfalls is the do-it-yourself method. And we see this from time to time. There are a number of different resources out there on the internet that will allow people to do these documents on their own. The problem with that is that power of attorney documents are highly scrutinized at a number of different levels, not the least of which is a bank, title company, or whatever. And these institutions are used to using a a certain form of document, and that form of document does not always exist in the do-it-yourself space. And so we would always caution clients or the general public to avoid the do-it-yourself method. That's probably the number one pitfall, okay? The number two pitfall that we would mention is knowing whether or not your power of attorney is effective at the time that you sign it, or if it is effective upon some later disabling event. And there are some pros and cons to both sides, but in my practice, it is normally the more recommended approach, especially with husbands and wives, to have a power of attorney that is executed and valid at the moment that it is signed. In other words, there's some lines, if you've gone through this process, you've probably seen this before, there's some choices that you can make that say, this document becomes effective upon my disability, or this document is not affected by my disability. The reason we normally want our clients to have documents that are effective at the time that they sign them is so that they don't have a bunch of red tape they have to cut through in dealing with a doctor or two doctors, in the case of a statutory durable power of attorney, to say, yeah, your spouse is disabled. Well, what if they can't agree? What if they can't decide? What if they can't even be found because their schedules are so busy? These are all the different types of red tape that we don't want our clients to have to cut through. And then if I was going to list just a third pitfall, it would be understanding that not all powers of attorney are created equal. Your general Main Street estate planning attorney has probably come up drafting powers of attorney in their regular form for every client that comes in. They probably all look the same. But if you're a client that's contemplating a disability down the road that may involve some sort of long-term care planning, it's important to know that there are highly sophisticated additions or subtractions that need to be made to those types of powers of attorney in order to accomplish that very specific goal. So those would be probably three pitfalls: is avoid the do-it-yourself method, understand the difference between powers that arise at the time that they're signed versus powers that arise upon a later incapacitating event, and understanding that there are more sophisticated versions of that document when used for long-term care planning.
So going along the same lines though, you mentioned a couple of times, you said ill or disabled. What if the spouse is deceased? Can I still use the power of attorney there?
No, unfortunately.
Why not?
That's a common misconception. Yeah, that's exactly right. So when we're handing that power over, we're handing that power over only as long as we are alive. And the reason for that is we have a whole section of the estates code that's dedicated to documents that are drafted to be used after death. Last wills and testaments, certain revocable living trusts that arise after death. And there's a transition period that happens there. So the short answer to your question is no, we can't use the powers of attorney after a person is deceased. Unfortunately, that's what the bank would consider to be fraud. So we don't want to have a person pass away and then go in and try to do some sort of financial transaction on the strength of their POA.
Well, I think, I think that there's probably a fair amount of people out there that don't even know that think that it's still good.
Yep, very common misconception.
In the case where there are siblings involved and I was the one and, I have the power of attorney, so I can go in and do that.
Right, that's right.
Wow.
Yep. And be careful about that.
So that's one of the things that we're going to have posted for you on your list, just kind of as a reminder of when that power of attorney will work for you and when it's not a good thing for you to use. Let's move on to a different topic, funeral plan. So when we're looking at funeral plans, and Bertha had mentioned earlier that she's been doing this for quite a while. As a matter of fact, she has helped John and I put together our funeral plan. She's very, very smart, and she makes it really enjoyable. Just to let you know that. But what are some of the benefits, Bertha, that you might tell our audience briefly about having a funeral plan in place?
Okay, I'm going to go quickly, just do a little list to let you know some of the benefits. One of the benefits of pre-planning is saving money on the front end. Another one is locking in a price. I don't know how many of you realize that you can lock in today's price and live another 40, 50 years and it will never increase. Another one is avoid family conflict. That's really big. I've worked with families for years, and in one in particular, You know, she said, oh, Bertha, my family is so close. They come every Sunday for dinner. You know, but once she passed away, sometimes the dynamics change. So that's a big thing. You really need to make sure you have everything in place. Another one is, you know, like Burger King, you have it your way. When you plan your service, you plan it your way. There's a difference between planning, because when you plan, you can get discounts. At need, when you walk into a funeral home, then you pay the prevailing price, whatever it is at that point. So that's another one. Prevent overspending. A lot of times when it isn't pre-planned and you walk into a funeral home, you want to spend with your heart. That could make you want to spend more. But when you pre-plan, you have time to think about it and really digest it and really do something that you need rather than on emotion. Another one is I get to answer all the questions. So right now is a good opportunity for me to be able to answer all of your questions about pre-planning. I have a search engine. Sometimes people say, well, I want to search price. You don't have to do that. Remember, my license is with the state of Texas. I can actually, with the click of a button, go from ABC funeral home to this funeral home, just in a matter of minutes. You don't have to worry about that. The convenience of having someone like me. Another one is to lift the financial burden of your family. When you pre-plan, everything is paid for. You'd be surprised how many people do come in and they have a death and there's no money. So that's another big burden lifted. Payment options. When you pre-plan, you have payment options. If someone passes away, you have to pay immediately. You only have about 72 hours to get those funds together. So that's another one. Every 8 to 10 years, a funeral cremation price will double in price. That's just what it is. So that's another one. You can transfer. So sometimes people think, oh, well, if I pre-plan with you today, Bertha, what if I need to move? Remember, we have over 2,400 locations. So whatever you do here, I can just transfer to wherever you are, and the price will never increase. It's just transferring. A few more, I have to let your family celebrate your life when you pass away and not have to worry about the burdens of trying to plan everything. They can do more of a celebration and be there for one another. And the stress, take away the stress of your family. That's huge. Another thing about pre-planning is we can do it virtually now. With the COVID, that gives us an opportunity. If you don't want to meet, we can do that virtually, no problem, or we can meet at any 33 of our locations.
Great, that's great. So in addition to the funeral plan, you know, what else can you do to help relieve the stress? I know that one of the things that you did for us, Bertha, was you shared this green book with us, and you had mentioned that we could write our own obituary. And in some of the research that Debbie and I have done together in planning for this event today, what we've learned is that if it's something that is an unplanned funeral, immediate, something happened, you don't really take a lot of time to think about all those things that maybe your loved one wanted to know. Of course, people want to know they were survived by, where they were born, where they lived last, maybe some of the things they participated in. But if you write it ahead of time, right?
Absolutely. So we have what's called the personal planning guide, which is the same guide that Ingrid is, just a different cover. We have a little bit more information in this one. But I suggest that each and every one of you reach out to me so that I can get you this guide. This has about 90% of everything that your family will need to know once you pass away. So this is an excellent, excellent guide. Another thing you want, I tell people all the time, if you have a spouse or you are from the military, you need to have those DD-214, that paperwork, because if you're planning on going to the national for burial, or if you're going to a private cemetery, you can also get your marker, but we need that DD-214, and that's something that you want to make sure you have in your hand. Another thing is passwords. You would be surprised, someone will pass away and that person, it's accidental, And that person was the one that handled everything. And the spouse, they have no clue what the passwords to get into that. So that is so important. You want to make sure you have that. Another thing, once you get this in hand and get it filled out, you want at least 2 people to know where this booklet is. Because when you pass away, someone needs to know where to get their hands on important papers.
Okay,
So
that's great. We've got some more for you as we go. So let's go ahead and move on from that. So we've talked about a couple of different things just in pre-planning from this, I don't want to say the simple side of it, but the power of attorney that is always good to have and keep updated, which we'll talk more about. We've talked about the importance of funeral planning, which is a topic that not a lot of people want to talk about, but an important one that we need to get handled while we can and while we have the time to do it so we can plan accordingly. Let's talk about a couple of other things that are going to be important to us, wills and trusts. So, you know, Lorne, tell us the difference in a will and a trust and why you would choose one over the other. We have a whole list of things that you've given to us, and I'll ask you to, you know, brief our audience on what those are.
Sure. So when we're talking about, you know, generally estate planning takes place in kind of 2 different buckets, right? One is disability. Who's going to make my decisions if I become disabled? We covered that with the use of the powers of attorney. The other bucket is normally the rather obvious, right? Don't shoot the messenger, we're all going to die. Who's going to inherit my property at my death, and who's going to be responsible for getting that property where I direct it to go? And so that's when we introduce the topic of do I need a last will and testament, or do I need a trust? Now, at the outset, I'll tell you, trusts are a lot like shoes. They come in all sorts of different shapes and sizes. And so the type of trust that we're normally talking about for general estate planning purposes, what we call the revocable living trust. In other words, it's a document, it's an arrangement or a relationship that you establish during your life that you can change at any point throughout your life. And so to compare and to contrast the two, you know, a last will and testament is a document that you sit down. It has certain strict requirements that the state of Texas has for Texas wills and other states have for other wills, whereby you lay forth in writing who you are, who the people in your in your family or friend circle are that you would like to inherit your property at the time that you pass away, and then also who you would want to manage your legal estate, be your personal representative.
This is will, correct?
This is a last will and
Make sure
testament.
to do it separately.
That's
will
correct.
And then trust.
This is a last will and testament. And many people are familiar with the concept of the will. Hollywood has done a fine job of setting up the formal will reading at the lawyer's office where we light the torches, and it's all very formal, and we decide, half the snotty children find out that they were left out of dad's will, and all of those things. When I'm explaining the process to clients, I normally establish for them that creating a last will and testament is a 2-step process. The first step is that you have to actually sit down and make it, and that is oftentimes when you, the individual, sit down with an attorney, you walk through what your plans are, and then the attorney normally writes down your wishes in a formalized document. You sit down and you sign it, and that's step 1, the making it process. And then time goes by, right? It sits on a shelf, and it really doesn't do anything. You might update it from time to time, but the second step does not actually happen until you pass away, so you're not even actually there for it. And the second step is the process of validating the will. And that process takes place through the state of Texas acting through its probate court system. In other words, that will, after it's been made, has to be offered to a court for approval. And the person that you name to serve as your executor has to be formally appointed, and they're appointed by an order of the court. And then the clerk in the county where you pass away is directed to issue documents called letters testamentary. Maybe some of you have dealt with this before in dealing with an estate of a parent or a sibling or something like that. And those letters testamentary become sort of like keys that unlock the doors that are locked from the insurance company or from the bank or whatever, and allow the person that's named to get access. The issue with the probate process is it can kind of be a headache. And in the state of Texas, it's not a backbreaking headache, but it's still a headache that can be avoided. I mean, you have to hire an attorney, you have to pay the attorney, you have to pay court costs, you have to go to court, and depending on where you live, depending on the county where the person passes away. All of this stuff can just be legal administrative headaches that may not ruin you, but again, they may just be things that you don't want to deal with. And so there are alternative ways to plan for passing your estate along, and a revocable living trust is one option for using that. And a lot of times when I bring up trust with clients, then they have certain bells and whistles that start going off in their heads about, well, I have to be super wealthy because it's families like the Trumps or the Kennedys or the Rockefellers that have trust. And it's true, those families do set up these trust arrangements, usually to avoid wealth or estate taxes. But that's not the context that we usually talk about trust planning with our clients. With our normal clients that are not looking at significant estate tax issues, what we're inviting our clients to consider is an alternative relationship where they can begin transferring ownership of their assets now into a new relationship called a trust that they still have control over. And the design of this arrangement is that they can control each asset that is held in this trust while they're alive. They can use all of the principal, or they can use whatever's held in this trust for any purpose whatsoever. So they don't lose any control over it. But the trust is designed so that at their death, the transfer of the ownership has already taken place. And therefore, anything that's held in the name of the trust avoids having to go through the probate court system. This can become really important if you have property that's located in other states, for example, where if you die in Texas, you have to open a probate court suit in Texas and then have to go open what's called an ancillary probate in Oklahoma to handle that fishing cabin, or in Colorado, or wherever you may own some property elsewhere. So for clients that own property in other states, trust planning becomes really, really important. Clients that are anticipating perhaps a later incapacity, trust planning makes a lot of sense for them because they're already pre-establishing who could step in and run the show. Very similar to a power of attorney, actually, but on a more broad basis. It also prevents some family infighting. If you think about famous will contests that have gone, I think about Prince, or the artist formerly known as Prince, and how 6 or 7 different alleged children stepped forward to challenge his estate in the Minnesota probate court. Trust planning is something that can avoid all of those types of things. And so, just to kind of put a bow on it, if you start from the foundation that for everything that an individual owns, some sort of work is going to have to be done in order to transfer that ownership at death, using the last will and testament would put that workload on someone else, not you, because it doesn't take effect until you die. Revocable trust planning allows you to do the work now on the front end, so as to, what many of my clients would establish as a goal, to make it easier on my family once I pass away. So they're in some ways 2 sides of the same coin, but in some ways they're not.
Yes, exactly. And I do think for John and I, we have put together a living trust, and we also have our funeral plan in place because we wanted to make sure, just through the experience that we've had with our families, that is going to be easier on our son in the event that something should happen to one of us or to both of us. I have some questions though for you, Lorne, that I want to ask. You know, when you're, and we'll get more into this because we do have another question coming up on probate, but my understanding is when you do probate something, it becomes public record. We could go, anybody could go and look up the information on that individual. Not only look up the information, but it would also identify if they had a will as well as their assets, correct?
That's correct. So when you open up a probate case, you're essentially filing a lawsuit. Now, it's not usually contentious where there's a plaintiff and a defendant, but it is, in the eyes of the law in the Texas courts, it is a lawsuit. And so because of that, it is a matter of public record. And there's a whole industry of real estate investors, that kind of troll the probate records to see what opportunities might be out there, and then you start getting the pink cards in the mail. And again, these are not backbreaking things, but they're just headaches that we can do without.
Right.
Yes.
Well,
so
during that time, especially, you don't want somebody calling you. I was the executress for one of my close friends, and even though I'm in that business, real estate business, I have people calling me nonstop, wanting to know if I was going to sell that house, how soon it was going to take place, because they come over and have a look at it. in my case, my client lived in a retirement community. Her house has been long gone. But it's stressful when you're trying to get all those other things accomplished and you have that happening.
That's right. And there are some circumstances where the entire inventory of the estate is required to be filed into the probate court record. So not only can people out there in the general public find out if you have a will, in some circumstances, they can find out what all you owned whenever you passed away and how much money you were or were not worth. Now, there are, the Texas Estates Code does have ways around that depending on who the beneficiaries are, but there are circumstances where you can go and you can just look up and see what an individual owned at the time of their death in their entirety.
Which is kind of scary. I mean, there's a lot of those kinds of things going on right now. I think that, we hear those commercials, home title law, protecting your title on your home. It gives people an opportunity to prey upon you because of public knowledge. Whereas if it's in a trust, it's nobody's business.
Yes, that's right. And as we kind of continue down this path that we're in the digital era, as the general population is getting older and fraud and identity theft is becoming more and more of an issue, more people are sensitive to the private nature that trust planning offers. And I'll just, I'll say, trust planning is not for everybody at the end of the day, but maybe it is at the beginning of the day for everybody to at least consider if this is a viable option.
Right. One thing that I want to bring up with you that we've had a conversation about, and I think it's important to know, for people that are, we've talked to a lot of people that have done this, especially over the past year, staying at home, being in your house, not really leaving. There's things you've decided, well, I'm going to go ahead and update that. I'm going to go ahead and make changes. If you have a trust in place, you can't do a home equity loan with the trust. Is that correct?
That's correct. Also, well, so in my experience, most banks, credit unions, if you go to do a HELOC, if you go to do a reverse mortgage, if you go to do a refinance, it's not that they will not qualify you. They'll ask you to take your home out of the revocable living trust until that lending transaction closes. But here's what we see more, unfortunately, all too often, is the client never puts the home back into the trust. And so for all of what I was just saying about trust planning avoiding probate, a failure to stay on top of that piece can actually undo all of that work, because if an individual passes away and they have not put their home back into that trust, it's a concept that we call funding. Funding is the actual process of transferring the title from you, the individual, to you, the trustee of your trust. And if that piece wanes after a refinance, then you can end up taking what was an asset out of that was not subject to the probate courts being in the trust. If it doesn't get deeded back in, unfortunately, it's likely going to have to go through the probate court system in order for that ownership to transfer. Even in the case of married couples, by the way.
Wow.
Yeah.
That's a lot.
Yep.
Well, that's a lot to talk about. Troy, did you want to weigh in on any of that before we moved on?
That was great.
Nice.
Definitely gives you a thorough answer, and that's good. I mean, trust, we are starting to see, just from my perspective, everybody just think, oh, I got a will, I'm good. Now people realize, or I should say, people are willing to really listen to that trust aspect and realize, oh, I realize all this was public record, or that it was easier, right? I thought if they had a will, they could apply for probate because of Texas, right, having a little bit more leniency, I guess, in probate court versus some other states. But yeah, I thought it was great.
One other thing that I would like to bring up that might be important for people is probating always necessary? Sometimes in the real estate business, sometimes I've found where if everything's pretty clean, there isn't any confusion of who's getting what or what's going to happen. We can do something called an heirship affidavit. So what is your take on that?
Well, to answer the question, is probate always necessary? Is the lawyer's favorite answer. It depends, right? It depends on what the type of assets the client owns and what the client's particular situation is. For example, I mentioned a home. there are planning techniques where even if you don't use a trust, you can take your home outside the probate process. Okay? You mentioned one of them, the heirship affidavit, which would take place after death. The state of Texas has a process known as a transfer on death deed, where you can basically set up a beneficiary designation for your house. Now, I caution clients on that because they're relatively new. Title companies are still relatively skittish. And so just for my personal practice, I normally only recommend transfer on death deeds for husband and wife client that want to leave to a single beneficiary like each other or an adult child and the house is paid off. Because I just don't want to, why would you take your client down that road if you can help them with a more, with a better plan in another area? Now, that said, there are other times also where maybe all the assets are transferred, but opening up an administration of the estate, which is what we call the probate, the full-blown probate in Texas, is advantageous. Maybe there's a potential for a Medicaid estate recovery claim out there, or maybe there are creditors that need to be properly prioritized. The formalized probate process can help do that. So again, not to be the lawyery, it depends answer, but it really does depend. Maybe there's a wrongful death suit out there, and the only recipient of the settlement funds is going to be the legal estate. And so it may become necessary to open a probate where otherwise you might not have had one because of asset transfer.
Question, I've heard that if you don't have a will at your passing, that you don't need to worry about not having a will because the state of Texas will create a will for you.
Sort of. So if you think about what a will does, and we mentioned this earlier, it says who you are, who your family members are, and who you want to be responsible for distributing your estate or managing your affairs, right? So in the will, you're answering all those questions. If you die without a will, the court has to answer all those questions on its own. And so I normally tell clients, if you die without a will, you're doubling everything. You're doubling the number of filings, because now not only are you asking the court to open a formal administration, you're also asking a court to formally declare who your legal heirs are. So that's where it becomes the state of Texas kind of has the plan for you, because there's a section of the Texas States Code that's devoted to saying, here are the default heirs depending on, is client married, is client single, does client have children, does client not have children, does client own community property versus separate. It's a whole big deal, but it is a predetermined line of distribution that may or may not follow who you want. We got to double the attorneys, because not only do you have to hire the attorney to open the probate on behalf of your client, the court has to appoint an attorney to go check this attorney's homework. It's a whole convoluted system. Don't die without a will is the bottom line there. So yes, it's a more convoluted process, but there are default rules. The issue is those default rules may or may not reflect what you actually want to happen with your property.
Okay. Having all of those documents that we talked about today, we talked about powers of attorney, we talked about wills, we talked about trust. How often are those things to be looked at?
General rule of thumb, we tell our clients 3 to 5 years is a good time to look it over. And then there are a couple of categories that we recommend. As your family situation changes, so people move away, people pass away, people get married, children grow up from being little to being adults, and maybe it's time for them to step into some of these decision-making roles. So family changes are always important. Financial situation changes, buy a house, sell a house, downsize, get a job, cash in retirement, start taking required minimum distributions. All of those times are good times to review your estate plan. And then as the federal and state estate and tax laws change. Now, most clients know these first two about their family. They're not usually staying abreast of what's going on in the third. So that's why we want to make sure that we are keeping our clients informed. You know, we have a new tax bill that's going to come out at some point, I would expect before the end of the year. And there are going to be some substantial changes to the way individuals' estates are taxed upon their death. And it may affect a number of different states. So we want our clients to be aware of that. So those are kind of your rules of thumb for updates there.
That's good. That's good. Now I know, Troy, for you, both you and Tricia have a plan with your clients as well. You work closely with the elder law attorneys that your clients may have, but also it's important for you to be apprised of changes that are being made. And so what do you do for your clients from the financial aspect to help them make sure that their wishes are being taken care
Well, it's a great question. So initially, obviously, when we're sitting down with the client and going through 401ks, helping with the whole financial planning process, we're going to be asking, children, we're going to talk about beneficiaries, right? But how do we stay up to date with that process? So we have what we call a beneficiary audit, and we try to do this, at least once a year. And that's because sometimes kids fall out of favor with the parents, right? Maybe they decided to switch the percentages, or, divorces, there's all kinds of things that can happen. So like I said, what we call is a beneficiary audit, and that really is sitting down with the client saying, we have Junior on here as a beneficiary, and then we have your daughter 50-50. Is that still correct? A lot of times a husband may have a wife as beneficiary, but there's no contingent. So they're passed away together on a vacation, or if she was to decease him, then who would be the next, beneficiary? So we like to really, when we go through the beneficiary audit, we really like to have those clients think of a contingent beneficiary, because if they don't have a contingent and the primary is already gone, then, that becomes a probate asset. And then obviously, you're dealing with that. So does that help answer your question?
Yes, it does. It really does. Minor changes to the will. So Lauren and I were talking about this, and a lot of times on TV, different TV shows that we watch, you may see where one member of the family gets upset, or as Troy said, one of the children in the family falls out of favor, so they take that pen and write them out of the will and write somebody else in on the will. And I wanted to know, I thought that I've actually seen that happen. I wanted to know how realistic that is. And if someone decides, I'm taking you out and I'm putting her in instead, what does that do to the will?
It's the fastest way to give your estate planning attorney a heart attack.
Oh,
Yes.
okay.
So handwritten changes on a typewritten will are not valid. And if you think about the strict requirements, for a will in Texas to be valid, the contents have to be witnessed by 2 witnesses. Good practice is that it be notarized. And so unless you're calling 2 witnesses to your side and you're notarizing every single time that you're doing that, and I'm still not sure that would get you across the finish line. We just don't make handwritten changes on our will. There is a process in Texas called codicil process, where you can make an amendment to the will. I even tend to shy away from those, because nowadays with modern word processing, it's just as easy to make an edit to a client's previous draft and then have them execute a brand new will. Why would we take the chance? You want to do as good a job to give your client an accurate rendition of their plan that's as watertight and contest proof as possible. So
Don't write on it.
don't write on it.
Especially if you start out in one case where you maybe had one attorney that you started working with, things have changed in your family, maybe there's a different spouse involved now and you've gone to somebody else and your paperwork hasn't been changed. That's important to keep everybody apprised of that. So, make sure that you have all of those documents available to you. They're oftentimes when we go and we meet with somebody about their property, we're looking for specific things. We're looking for the survey on their house. We're looking to see what kind of updates they've done recently that might impact the price on their house. The other documents that are just as important are going to be the things that we're talking about with our experts today. Make sure that you know where they are, whether they be in your safety deposit box or in the top drawer of your filing cabinet, but where you have easy access to them, or somebody else does that needs to do that for you.
Ingrid, I would offer one and only one exception to that rule, which is if you have a medical power of attorney in place that has your medical decision makers' telephone numbers on there, and those telephone numbers change, I wouldn't advise it as a long-term plan, but I do not have a problem with my clients scratching the old phone number out and writing the new phone number, because practically speaking, in a medical emergency, your hospital needs the most up-to-date information possible. And so is a changed phone number going to invalidate that document? I would say absolutely not. And you don't want them dialing a bad number in order to get in touch with your medical decision.
Good point.
So.
Good point. Troy, so I've experienced this in my own family, and I have heard people that I've worked with in the past make this comment. I have accounts all over the place. Or when my father passed, we didn't realize that he had 3 other life insurance policies that nobody was aware of. Is there any way to keep track of these things so that, like the documents that we're talking about and the updating, that we can have those available, not just for ourselves, but others that are involved?
Yeah, so I would say certainly, but I know not every financial planning firm that I've seen, you obviously have friends and peers in the business, not all of them use the same software, right? So there's many versions out there, but we use what we call e-money planning software, and it's been the number one rated software out there for years now. And Berkshire Hathaway, just a side note, Warren Buffett, they love it. Been using it for years, but we like to use it because it helps. Basically, it's a dashboard. It has you can put as much information on there as you possibly can. We help clients, we encourage clients to do that. So it's a single sign-in process. They can see their checking accounts, saving accounts, loans, anything. So as well as their retirement accounts and things of that nature, investments. So it really helps either the spouse or the executor, but really just consolidation, right? So something happens, you know where everything is, right?
So is that something that I myself could go and download that app and set it up myself, or is it something that someone like yourself as a financial planner would set up for me and share with me?
Exactly, Ingrid. So it is not a DIY or you can't do it yourself. So it is something that we pay for as a firm. It is expensive, but it's also very expansive software, and it's not. You have to have a relationship with a firm that uses that. Now, there's other ones, I'm sure Fidelity or these other firms may have something where you could maybe do single sign-on, but I would doubt that it has the expansiveness of what we use.
Okay.
But
that just happens to be one that you like, but there are others out there.
Yeah,
if they're working with a firm, they want to check to see what they're using.
Exactly.
Okay, all right. So, what are some of the ways when our spouse passes to ensure that we have access to our accounts and our money, as far as you're concerned? Because I know that, if something were to happen to John, I would be coming to you and saying, I need help with this, and how do I find out what I can get?
Right. So obviously, joint accounts, right? So you and John on the same account. But I definitely encourage clients to have rights of survivorship on there, so it avoids the probate process, right? They're able to access those funds to help pay funeral bills or the bills that are coming in with a person while you're going through that process. So I definitely say joint accounts, payable on death accounts, at the bank, with investments. It's not payable on death, it's called transfer on death. And my understanding is that does trump the will. So if your will says everything's going to Lorne or Bertha, then your transfer on death says it's all going to Johnny, then obviously that's where it's going. So,
wow, I didn't know that.
Right. So that's why the beneficiary audit is very important. And a lot of times clients are like,
I'm busy. On our list, Debbie.
So like, I'm busy. It's the same beneficiary I had last year, and sometimes they don't realize, there's a lot to it. So definitely transfer on death on those investment accounts, payable on death with your bank, checking, savings, and then also joint accounts can certainly help you there.
Okay, so we have an IRA, and we want to put them into our trust. How is that done?
Well, unfortunately, a trust cannot own the IRA. It can be the beneficiary of the IRA, right? And I've had a client kind of learn that the hard way, and we had to go through he was dead set. His attorney was out in California where he had some family, and he was like, I need this in my trust. And I'm like, I'm sorry, you got to wait until this person passes away, and then that trust would be trust as beneficiary, but you can't technically own that trust because of, I'm sure a lot of you guys have probably saw when you looked at your 401k paperwork, you might have seen the acronym ERISA, or a lot of people say ERISA, but basically that plan that was passed by Congress keeps the trust from owning that. It can be a beneficiary, but it technically can't own it.
like a trust could own a real estate property, but it can't own an investment.
Over time. And then IRA has creditor protection. There's certain things that are around that, that help out getting retirement dollars. And so, that's why a lot of reason to it.
One of the questions I want to pose to both of you, Troy, I'll pose it to you first, that you had given to Debbie and I. Speaking of beneficiaries, if I have a beneficiary listed on my financial account, this may be kind of like what you just explained, but I also have them in my will or my trust that leaves my assets to a different person, which one takes precedence? So we talked about paid on death and transfer on death. That would take precedence, correct?
Right,
But
right.
is there anything different there?
Well, I mean, there's, like with non-probate assets such as life insurance, you know, it's going tax-free to those heirs, things of that nature. So, you know, I say precedence, I mean, it's, well, it just depends, right? Like the great lawyer answered, right?
Yeah,
I mean,
what do you have to say about that?
Well, so rule of thumb, beneficiary designation is a trump card over the will whenever it comes to any asset that you can declare a beneficiary for. So I'll give you, well, just nightmare scenario happened. A client came to me recently with this one. So they have a life insurance policy that is payable 50% to their surviving spouse and 50% to their daughter, okay? Actually, let me back up. It was 50% to, that's right. 50% surviving spouse, 50% to daughter. And then they had a will, and in the will said, I leave $50,000 to my ex-wife from this particular life insurance policy. And they named the policy by name. That is a huge problem. Because think about what's happened, okay? They've already predetermined 100% ownership of that account. They left it 50% to surviving spouse, 50% to daughter. Well, who among those two people should be expected to kick in $50,000 so that this ex-wife could get money? That's not how it works. No, the beneficiary designation trumps anything that's written in the will. Because again, Troy mentioned it, right? We're talking about what we call probate assets. In other words, assets for which court involvement is required to transfer the title versus non-probate assets, which are assets that automatically transfer based on the beneficiary designation. Last will and testament, it only handles those probate assets. So it's not even to be a consideration over here. Now, having said that, said the lawyer, let me give you a situation where things can get really crazy if you're not working with someone to stay on top of this. Say that I name my surviving spouse as my first beneficiary. I think you mentioned this move. I name surviving spouse as my first beneficiary, and I do not name a second. And then my spouse dies before I do, and I never update my beneficiary designations. Who is the beneficiary of that policy? It's my estate. And so in the example I just gave you, if daughter and if surviving spouse had both predeceased the account holder, then that surviving ex-wife would have gotten $50,000 from that policy because that account would have become, man, you can create a bird nest really, really fast. So this is why, and I think Haber's beneficiary audits on an annual basis are killer for this particular issue. Staying on top of who those beneficiaries are and who they shouldn't be, and making sure that the non-probate asset doesn't end up going through the will process.
I think so too. Moving right along then, so let's talk about adding money to our investments. What is the Secure Act and how does it affect a retirement plan? Troy, we'll go to you first.
Right, so that's a fairly new law that passed here at the end of 2019, but a lot of folks still haven't realized that it's gone into effect, because last year I got a lot of calls saying, hey, you're gonna take that R&D, and I'm like, hey, luckily this year, at least with COVID, they allowed you to skip that, but now your R&Ds, the age has gone from 70.5 to 72, so they give you a little bit more time before you have to start taking those distributions out of the account. But regardless, if you're still working, now they allow you to continue to contribute to the IRA, which is important because before at 69 and a half, even if you're working, you couldn't contribute, you couldn't continue to save for retirement. Also, if you inherit money in an IRA or a 401k account, you used to have to basically stretch that IRA over your lifetime. So let's say you inherited your parents' IRA account and you're 55 years old, well, you have a certain amount, they're gonna stretch it out over your life. So let's say your lifetime expectancy is say 78 or 80, you're gonna stretch out that little bit amount of money that you take out of the IRA each year that you inherited. But now, you have to basically spend that in 10 years. So they are forcing you to take more money out of that account faster. So obviously Uncle Sam can get their hands on those tax dollars. But those are a few of the changes that the Secure Act has affected retirement plans.
Do you have anything to add to that, Lorne?
The other thing I would add is that there are certain types of trusts that don't upset that. So like a surviving spouse is still one of those qualified beneficiaries that can stretch that IRA. If you have a trust that allows a surviving spouse immediate access to those types of funds, and most revocable living trusts do, that does not upset that Secure Act planning would be like the only thing I do.
Okay. So far what we've been talking about in our seminar today is a lot about what do we need to do while we're together, while we're of strong mind. That's really important. And we wanted to make sure and touch on those things that are not everyday conversations, but really important things for us to do as we are aging and just really planning for ourselves and planning for our families. Things that we need to do when we're a we. Let's just kind of do a quick review of that. I started that earlier. Be honest with each other. Let everybody know what you have going on. What's happening. This is something that I and John both, the two of us, run into all the time. One or the other spouses passes, and the person that's left behind feels paralyzed. I was not the one that paid the bills. I never took care of the car. He always took the car in to get it serviced. I don't even know where to take it. Oh my goodness. What account do I use to pay for that? Oh wow. I don't even know how to use the remote. He had all the shows programmed on our remote. I'm not even sure which one to press. It sounds funny, but really and truly that happens for a lot of people. So we're suggesting, if you have an opportunity to, and Lampkins, I'm going to ask you to do this before I see you next time. Swap roles. Joan, you do everything he was doing, and Kurt, you are now in charge of laundry, making meals, and all those things that Joan has worked so hard on. Because it's not just the women, it's the men as well. She did everything. She was the socialite in our family. I don't know any of those people. So it's really important that you take the time to do that. And we suggest, maybe you set a goal. Doing it for a month may seem like a long time, but it may be something worthwhile trying because you feel more bonded, if you will, because you can support each other in those things. Other things that are important for us to keep in mind here is create a home operations manual. So while you're still living at home, put together a manual. You're already saving, I hope, receipts on things that you've done. Who do you call to service the air conditioner? When did you put the roof on last? Those are things I'm going to ask you for when we come out to visit you. But put together that home operations manual. Where are these things stored? How about this one? I have to be honest with you. I really don't know. If something were to happen and a breaker went out, I'm not really sure which one to go on the breaker box. And I'm asking those of you that are with us today, how many of you, Joan, do you know which breakers to pull?
Well, only because they're marked on the box.
Okay. That's really an important thing. So home operations manual might be a nice thing, even as a gift, to give to your loved one, whether it be your spouse or whomever, so they kind of know how things run around here. Discuss plans for your home, about your home with your senior advisor, your senior real estate advisor. If you've got a long-term plan, but you want to kind of get your ducks in an order, if you will, what things do I need to do? I'm not ready to do anything today, but I want to plan ahead. Might be worth the time to do a consultation and get some ideas. I have a couple of people right now that I'm working with, and they've said, just come take a look and tell me what would I do while I have time, while I'm planning. So that would be important to you as well. Let your children or your trusted friends know your plans. We talk about that a lot in our seminars. If you don't want to do it formally, write it down somewhere, put it in an envelope and let them know where it is. Whether if it's in your safety deposit box, how do they get into it to find it? But somehow, so that they know at that time when they're grieving, what do I need to do? What did dad or mom want? Where do they keep these things? This is a big one. Build social relationships while you're away. It's easier a lot of times to do those things together because you or your partner may not be the outgoing person. So build those friendships together while you're away, and in the event that you lose your partner, you know those people that you met together and you're able to do things with them. Engage in social activities. We talked about that. Now, I mean, we haven't been able to do that for a year, but now we're starting to see where we can go to our churches if we choose to. We can start to delve out and go into restaurants if we want to, but do some things together, hobbies together. And then in the event that your spouse or significant other is terminally ill, plan to look and search out grief groups so that you can plan ahead for those things. All right, well, let's move forward then. Now we're going to talk more about the me side of it. So let's move to a different section. Debbie, how are we doing on our time?
It's 3:15.
3:15. All right. So what things that we want to talk about as we are now going from being a couple or having someone with you to, and I say it like that because I know of several couples that John and I know together that they are together as like husband and wife, but not husband and wife because their benefits would change if they were husband and wife. Husband's veteran benefits, that kind of thing. So when I say it like that, that's what I'm referring to. Lauren had gifted us a really great book that we've noted in the handout that you're all going to be getting afterwards today. But I would suggest that you have a look at getting this booklet. It's called The Survivor's Handbook, The Essential Guide to Financial Matters After Death. And it's just a very easy read, but it's got some great information in there that we'll talk about here in just a couple of minutes. But it's called The Survivor's Handbook. You can get it on Amazon. And the author for this book is Thomas Stevens. And I believe the way that I understand from you is that he wrote this after losing a loved one.
Yeah, I don't know Mr. Stevens. He's an attorney and financial advisor down in Houston. I was looking for just a good desk reference and happened upon it. And his story is that his wife had a long battle with cancer. I think he writes about it on the back. His wife had a long battle with cancer. And in going through that process, he just compiled some of the practical, pearls of wisdom regarding dealing with taxes and legal documents and the emotional connection and Social Security and all of these different things. And so I keep a copy of this. I actually have a copy in my bag right now. Just whenever a question comes up that maybe I don't intuitively know the answer to, I use it as it's a great desk reference. So yeah, I highly recommend it.
Okay, great. Well, I'm going to ask, I have some things that I want to ask, and I'm just going to kind of run through my list, and you can fill me in if I've missed something here. But as far as what are the things I need to do as a me right away once I lose my loved one? I've got here, if the spouse dies at home, notify hospice or 911. Call a close family member or someone, a friend to lean on, because you always need support. Arrange for organ donation, possibly body transportation, and notify your primary physician, especially if they were in the hospital and their primary physician was not the physician at the time. Notify family and friends, reach out to your attorney or your financial planner. Arrange for care if you have, for example, you could be grandparents and your grandchild is living with you because you are now taking care of them. That might be important. Arrange for care for your dependents and for your pets. And something else that we talked about earlier is to make sure and to secure the decedent's home, the valuables, and their mail service. What would you add to that?
So these are all important things that have to be done at certain points as just incident to the business of dying. But I'll say that having actually lived through this on a couple of different fronts, my mother lost her husband 7 days before Christmas Eve. My sister lost her husband 4 weeks ago. You don't have to do anything. You need the time to process what's actually going on, even if that is holding yourself up in a room. I mean, we all got people that love us, and if you've ever been a part of this, folks are going to show up from church. They're going to bring more food and paper towels than you need, and managing those people can become in itself a burden. All people want to do is love on you, but they all want to love on you in a tidal wave at the same time. And so one of the most important things that I see on here is actually call a close family member or friend to lean on. I call them a wingman. Call a wingman that can act as a gatekeeper for you. Give them your phone just for a time so that you don't have to respond to every text. You don't have to respond to every Facebook comment. Oh, I'm so sorry this happened to you. You don't need to hear that right now. You need to be in your grieving space and then let somebody else take that role on for you. You got 4 years of probate or will, so I would locate it, secure it, make sure you don't lose it, but don't feel like you have to rush off. I would recommend at some point somebody make a call to the attorney, somebody make a call to the advisor and the accountant, and just surprise them with the situation. But in the very immediate space, I would say have a friend that you can lean on, and then probably the first item of business is you need to know what your sources of income are and what your liabilities are, especially if you're not the primary bill payer, because that's probably the most immediate thing. You know, the utility company doesn't care that your husband passed away. That bill's coming in 30 days, every 30 days. That meter is going to get read. Same thing for the car note and house note and all that. And so, you know, probably calling your advisor first, especially if you're on a fixed income, to find out what streams of income you have coming in and getting the Social Security benefit tied up to surviving spouse level, that would probably be the first business thing to handle. But before that, just managing the emotion of the moment and giving yourself the space to grieve.
Troy, did you have anything you'd like to add to that?
Lorne did great. That was good. Trusted advisors, like I said, lean on somebody, and then a lot of times it's like I said, family member, friend. But yeah.
And I do think that the big emphasis on letting other people do that and just taking that time, because it tends to build up for later, and then it's harder later to do that. Bertha, just briefly, once I've taken care of the immediate needs, what are the next steps I need to take as far as the funeral? So I've pre-planned. What do I need to do now just to make sure that everything's ready?
So once you pre-plan, I really recommend that you let at least, again, 2 people know where all your important documents are. So you want to secure that. You want to make sure that if a veteran is involved, you have those DD 214 paperwork. You want to make sure you have all the paperwork, your birth certificate, your Social Security, marriage license. Make sure you have all those documents ready at hand, because it's so important that when something happens, you don't have to fish around and trying to find things. So that's going to make it very, very easy for you. Make sure you try to get as much, even if you don't want to write an obituary, if you can bullet point. Get some bullet points of some highlights you want of that obituary. Funeral directors will help you with that. So that's quite okay.
Okay, great. So, you know, when you're gathering all these documents, you mentioned marriage certificate, birth certificate. Are those documents that you would want to make sure that either of these 2 individuals would have as well?
Yes, you can certainly have this, and you know, the biggest thing is reach out to me so that I can get you this nifty little book here, this personal planning guide, because again, it's gonna have about 90% of everything that you need. There is also a pocket on the back that you can put some important documents in there as well. So this is really good. And I just wanna say, if you are a veteran, I do have a veterans planning guide for you so that as a veteran, you know what your benefits are, so I can get this to you as well.
I think one of the other tips that Debbie and I were talking about earlier today that's worthwhile mentioning is if you are, because we talked earlier about how much of your information is public knowledge, keeping in mind if your will is being probated or once someone dies, that information is available. So you might even think about on the day that you are having a funeral, that someone comes to your home and stays there at your home for a couple of different reasons. One, to greet people that may show up afterwards. They're there to greet them, like Lorne talked about, let them handle that. But also to protect your home, because people know this is happening, the obituaries in the paper and other places, this is happening on this day, and to protect your home. Those are things that we didn't used to have to think about. But nowadays, with things going on, we want to make sure that everything's covered and that we've protected our home. After the funeral, you know, what other things do I need to take care of? I've got a couple things here I want to ask you guys about. Find the will and find the executor or the estate planning documents and consult your attorney. Consult your attorney either way, especially though if it's a different attorney that you're working with.
Oh, for sure. Yes, and if you've established a new relationship, you know, the estate planning practice is a transactional practice, so a lot of times clients will go to one for planning, and then they'll go to another for planning years later, and then they'll end up using another one that they met recently in order to do the probate. And so, you know, if you can keep those documents protected in-house, we mentioned, you know, fireproof safe or somewhere similar to like that. I normally recommend that clients avoid the safe deposit box just because of all of the hurdles that can be involved with trying to get access to that. If you can keep those things in the house in a place where it's protected from kids, dogs, fire, water, grandkids, whatever, but also with sufficient access where people can get this. We want to secure those documents, but again, the statute gives us 4 years before we go to probate, so we don't always have to run off. Now, sometimes people want to do things sooner. Maybe mom wants to get out of that house now because it's time to downsize and move on. She wants to do that sooner rather than later, so then there's some things that need to be done there.
Right. The other thing too is research and filed a life insurance claim. So one of the things that I found today, which I thought was a great resource in this book, is it lists all the names of all the different life insurance companies out there. In the event that you're unsure about, you know, who they are or what they might be, it's nice to have access to that so that you can file those claims that are necessary. And then when it comes to other things, because this is after the fact now, credit cards, money, it's important that you do some things at specific times. Troy, I'm going to ask you this question. You know, I was listening to a different seminar, and one of the things that the gentleman said there that really made a difference, and John and I have experienced this in a couple of different real estate transactions a few years ago, is who is the executor of the property, and if it's not one of the family members, is it the bank? And is it a good idea to notify the bank after the loss of your loved one right away?
Right. So sometimes if you do that, if you do let them know, they can freeze the accounts, right? Or stop access.
Keep you from paying the bills.
Exactly. So be careful with that and understand what kind of account it is. Obviously, if it's credit card, you know, there may be some pending monthly charges that are being you know, sent that way every month. And so you want to make sure you look back maybe 6 months, maybe a year, and kind of see, you know, what's coming out of the account. Is it a monthly charge? What is it? You know, is it HOA dues? You got to make sure you get paid. It's obviously, you know, when people are about foreclosure, you know, you get an HOA besides just taxes.
Right.
So those are a lot of what you have. I know obviously Social Security Administration, you're gonna.
Right, how do I make sure that I get the very most? Can I get my social security benefits and his?
Right, so no, so you'll get a one-time $255 death benefit. I still don't understand why that's the amount, but, I've been up to in years. But you get that, and then whoever had the higher, and we help a lot of our clients when we go through this as far as the Social Security Analyzer, so we can help them understand when the best time to take Social Security is, because it may not be at 62 when you first get it. But we'll help that spouse, if the wife passes, the husband got a bigger benefit than she did, then she'll lose her benefit, and now she'll get his Social Security benefit. As far as answering the question on the bank accounts, yeah, you gotta be careful with that, because you can't get it tied up, where the bank freezes it, they put it in the state account.
So how long would you recommend that you wait to notify the bank?
Well, you can, as far as taking their name off the account, it could be up to upwards of a year, 6 months to a year. But you may not, and it depends on what you're dealing with, but if you're not dealing with, if there's checks coming in that they have the spouse's name on, you wanna make sure his name is still on him, or her name is still on the account.
Okay, and what about credit cards? So on credit cards, I mean, in some cases, are there some that in the event of the death of someone, that bill could be paid?
Right.
Or would the spouse have to take that on? I guess it depends on who's on that.
Well, I'll speak to it a little bit, and Lorne, you can finish it off. But basically, if in Texas, it is a community property state, but not a community debt state. So if you're if the deceased is the primary account holder, and there's no other account holder on there, you may not have to pay that bill, right? Or something. We'll talk about medical later, but with the credit card, you have to be careful. But if both you guys are signers on that account, then you're still responsible for that debt.
Yeah, so whenever it comes to debt, normally the rule is that if the creditor has agreed to look solely to one spouse, then it does not qualify as community debt. But I will say those instances, in my experience, are rare. Now, that being said, there is so you asked about credit cards earlier. I normally tell clients if the amounts are small enough and there's cash available immediately, you might as well go ahead and pay it off and just get it off your table. Now, having said that, there is what's called a priority of claims order. There's like 8 different categories if a probate suit is open, right? So the IRS always gets to go first. And then it's usually going to be your secured, unpaid medical bills, secured property, so your mortgage, all of that, and then unsecured, and then child support or something. So anyway, long story short is the unsecured creditors, so your credit cards, your loans that are unsecured by collateral, with no collateral, they're going to have to stand in a rather long line most of the time. So it's not that they won't ever get paid off, but they could potentially, and there's some strategy that goes on here if you have an insolvent estate. But anyway, forgive the digression. If there's money available to pay the credit card off, I say go ahead and pay it. And that way, it's one less thing you have to worry about. And you keep a credit card available if you need to use it down the road for other expenses.
Okay, all right. Bertha, is there anything about, in your situation, if something happens and that person is paying for their funeral benefit?
So one thing about pre-planning is if you do an insurance, there is that benefit.
Mm-hmm.
So it'll pay itself off, and individually I can get into that with you. But let's say you have property. That's the biggest thing in the funeral home. If you have what's called a lawn crypt, well, that's where 2 people is going in one. You have to make sure that both are paid for. So that's the lawn crypt. You have to have the complete property paid for. If you have side-by-sides, you only need to pay off completely that one space for that person, and then you can continually to pay your own, as for the other side. So those 2 things I try to make sure people understand, Anytime you have one space burying two people, one person passes away, you're obligated to pay the entire bill off. Except when you have two pieces of property, one person passes away, you can pay the one space off, you have to, and then you continue to make payments on the second.
On the other one, okay. A little bit about identity theft. You know, that's kind of a downer to talk about, but it is an important thing for us to keep in mind. You know, I mentioned earlier about title fraud. You want to make sure that if the home that you're living in is paid for, that you have a resource that will protect that for you. John and I were talking about that earlier today, and I believe, John, you said you've got a notification set up with Tarrant County that if there's, can you just briefly explain that?
Yeah, you can set up an alert, but in our case, we're in Tarrant County, but anytime somebody files a document with your name on it, you get notified. So even though my middle initial's in, sometimes I get just John Sullivan or something like that, just out of abundance of caution, they notify me every time somebody files a document, a deed or anything like that. So you can see if somebody would file a fraudulent deed or lien on your property.
Yeah, great. Thank you for sharing that with us. Send the death certificates to the credit bureaus. That's important that you do that. Cancel the other person's driver's license. Again, it's real easy to get into that information these days, so you want to do that. And especially you want to do that if in the event that one of the surviving family members is a junior. So you want to make sure that the credit bureaus know that that senior is gone and that it's not going to impact juniors' credit. So that's important that we take care of those things. Something else that we have here that's important as we're wrapping up today. I don't know if I can live alone in my home after my spouse passes. You know, what should I do? So as Lorne said earlier, you've got time. That's really important. You don't have to do any of those things right away. You want to wait. You want to have an opportunity to feel better about what's going on, feel more secure about operating on your own. Take the time to grieve. Don't panic. Wait a year to make big financial decisions. And I think a lot of us have heard that. I know that I hear that a lot from people that we work with, that their grief counselor or their church or their attorney has said, let's just wait a year and let's kind of see what happens before you make any big changes. But try your best after a certain amount of time. Don't self-isolate. That's important too. You don't want to do that. You want to be able to spend that time, if you can, with your loved ones and try to re-engage with those individuals that are meaningful to you. Just like the slide that we have up right now, you know, don't panic. One of the things that someone had mentioned, we were talking to a grief counselor, she said that, you know, if there's a lot of things that we do together. I'll use John and I as an example. John loves to play golf. Years ago, he won a big contest, and the contest was going to take us to Hawaii, and of course that was exciting. And he mentioned to me, he said, I said, that's great, you know, I'm going to look forward to that. And he said, I said, you play golf in Hawaii? And he said, that's great, and you're going to play it too. And I said, I don't know how to play golf. And he said, not a problem, I already set you up for lessons. Well, at the time, we were living in Colorado, and this was in November. And I'm standing out in a driving range, I guess, in the snow, hitting that, or I'd be in a store, a sporting goods store, hitting, and I'd say, well, if that was for real, how far, you know, would that go? But it was really never my love to play golf, but I did it because he wanted me to do that with him. Those are the kinds of things that, you know, or I love fly fishing. My wife doesn't like it, or vice versa. And if you've lost your spouse, now's the time that you want to pick up those things, the hobbies that you really didn't do before because the other one didn't really like it. You know, think about that. What would I do in the event that I had this kind of time on my hands? And we're so used to doing things together, because we really are. We more and more, we rely on each other. We don't really have separate, I have my friends, you have your friends. They're all together. So think about doing those things that make a difference for you. Okay, so who should be on your team? Planning is really important as we do this. We've talked about a lot of stuff today. Thank you all for filling in our guests with great information. This is a perfect time for us as our lives are getting back up and running again, that we pay attention to these things. We want to do the planning that we've talked about today, and we want to make sure that we have the right people on our team. You want to make sure that you have a good attorney on your team. You want to make sure that you have a good financial planner, someone that can work with you, whether you're a multi-million-dollar client or less, but somebody that can make you feel comfortable about having your things in order. A pre-needs planner, and for the longest time, I really didn't understand that term, pre-need. I wasn't sure, do a pre-need for my party, pre-need for, so you want to talk with someone like Bertha that can really help you make those decisions to make you feel more comfortable. And you want to have, especially in your later years, you want to have someone, a real estate agent, that focuses on seniors. Because I think we all would agree that the type of transaction we would do as older, 55 and older, 60 and older and up, is so much different than something we're going to do for our first home, or moving from our second to the next big one, or maybe the next smaller one. There's a lot of stuff that goes with that. So you want somebody that has an idea about how that works and a passion for helping you to make you feel better about that. So we have questions. Debbie, what do we have from our Zoomers?
Nothing in the chat. If anybody has a question and wants to unmute, you can do that now.
While we're waiting, do you have somebody?
No.
Okay, while we're waiting for them, is there anybody here today that has questions? Yes, Vince.
Okay, on a will that was created, one of the beneficiaries passes away. The will has not been changed. Should it be changed?
Repeat.
So the question was, make sure that I got your question correct. There's a will that's been created. One of the beneficiaries has passed away, and there's been no further updates to the will. Should the will be changed? My answer would be yes, in general, probably because it sounds like it's been a while since that will's been written to begin with. But two, if there's no direction for whatever the individual that created that will, if there's no direction for that estate, then the will is not really meeting its intended purpose. And so it's probably time to sit down and do an update so that, one, that deceased beneficiary can be removed and new beneficiaries, whether they're individuals or charitable organizations or whatever, can be inserted so that it can really reflect whatever the plan, whatever the plan is. Because the individual who made that will, their plan is probably not for it to follow some sort of default sterile scheme in the estates code. So yeah, I would recommend an update for that.
Plan was set up, somebody passes, the amount in the estate goes to the remaining.
Now, if there are remainder beneficiaries, at least there is a place for the estate to go. And so again, not a backbreaker, may be worth considering an update, particularly if that deceased beneficiary was also named as an executor in that will, which is sometimes common.
Thank you.
It's a good question.
Other questions? Yes, Joan.
We have a revocable trust. And I wonder about this all the time. How would you start the process? Do I have to have a lawyer to help me with the what's in the trust, or can I just start the process of selling the house? Or I mean, how does that work after somebody dies? You have to involve an attorney.
Of course you have to have an attorney. I mean, why would
And you have everything's in trust, so it's yours. There's no legal thing there.
Right. So let's use one example and see if that will help answer. So the question is, we have a revocable living trust set up. How do we go through the process of actually using it after someone passes away? So we have to start from the concept of, has the trust been properly funded? In other words, has everything that needs to be retitled into the trust been retitled into the trust? A very common illustration that we use is creating a trust is like building a house. Funding it is like moving your furniture into it. If you build a house and it stays vacant, it hasn't reached its capacity or its intended use. But let's use the example of a home. And this would be very common, a very common planning scenario. If I'm sitting down with clients, we do a revocable living trust, say, we've got to fund the trust, otherwise the law says it doesn't work. So here's a deed that we've drawn up, and the deed says, husband and wife individually transfer to husband and wife as the trustees of the husband and wife revocable trust. Here's your legal description, here's your address. And in our office, we take up the mantle to actually record that deed. Now, between you and I, it's legal once it's signed. The rest of the world goes on notice once it's recorded. But let's say that that process has happened. And so now you get your appraisal district statement and it says the husband and wife revocable living trust own this home. Whenever you go to sell it, really no further action needs to happen. The title company is going to ask you for some documents. They're going to ask to see either the trust document itself or a shortened version, which we call the certificate of trust. And that document evidences whoever the trustee is, and they're going to be the ones that have the right to sell the house. So in that example, unless you just don't understand how the whole thing works, you wouldn't need to involve an attorney for that. Now, what happens other times is I'll have clients that say, we just finished a refinance, can you please deed the house back into the trust? And then we draw up the deed and we do the same thing. So it's fact specific and it's also asset specific. Some banks are really easy to work with whenever it comes time to add a trust to a bank account. Wells Fargo is one of those. Some banks are really hard. Sorry, Chase bankers, but Chase is probably the most difficult one that we deal with in trying to get them tied to accounts. Just to be fair, Bank of America is somewhere in the middle of the big banks.
So her question was, where do you get started? How do you get started? Do you need to do, you said you don't need an attorney, but what would be the next step?
Well, it depends on the decision that you want to make. If your accounts have been titled in the trust, you don't have to do anything. Life continues. The trust document, from a planning perspective, is designed to be a bridge from life to death. So there's not any new thing that needs to be done if the accounts have been tied to the trust. Because normally, if you look in the trust agreement, it's going to say something like, husband and wife have the right to use anything in the trust as long as they live. Once one of them passes away, the survivor has the same right. So life continues, from a financial standpoint, life continues as it always were, even after the death event. But then it becomes a matter of, well, if I'm selling a house, that's a new decision. The documents are already arranged where you can do that. But in trust planning, I guess this is what I'm trying to say. In trust planning, the death event does not necessarily create something new. In other words, it's designed so that it can be a bridge and that life can continue in the same ease, take the emotion part of it, but life can continue with the same ease that it was when both spouses were alive. That's kind of the idea.
And we have our daughter is, executor. So if, say we both die in a car accident and the house or whatever the trust is, she would have to go through an attorney because it would all go to her.
It wouldn't be required the same way that
Actually, it goes to all of our kids.
Right.
But she's the one that would be in charge.
But if she's the trustee of your trust, she wouldn't be required to use an attorney the same way that she would if she were probating a will. Like the law is going to require her in a probate scenario to use an attorney unless she herself is an attorney, because otherwise it would be the unauthorized practice of law. In a trust arrangement, she might consider talking to an attorney if she didn't understand how to discharge her duties as the trustee, but she wouldn't be required the same way under the law as she would be in a probate situation.
And one last thing is, what takes precedence, the beneficiary or if you have the trust, and you have all this set up, and then you go and you buy a new car, and you, like, it would go Kurt or Joan on the title, and so how would that work?
So if,
It would be, Kurt and Joan, yeah.
so if you're saying,
Kurt or Joan, it would be Kurt, yeah.
you're saying if you've designated, and you can now in Texas, by the way, you can designate beneficiaries for your cars. You're saying if you've designated the beneficiaries, what takes precedence, the beneficiary designation or something different in the trust?
Right.
The beneficiary
Right.
designations would trump,
That's
yes.
what I thought.
Yeah.
So if we want to defund our trust, we could just put the beneficiary on it, the beneficiary would take precedence.
That's the general rule, yes, ma'am.
Sorry.
Anything from our viewers?
I have a question.
Yes.
Yes, okay, you mentioned having a power of attorney. I set up my will and trust a few years ago. So what I have listed, power of attorney, when I did that, I haven't looked at it. It's in a safe deposit box, like you, and you recommended not doing that, but my son has the other key and his name is down as having access. So I assumed that was enough protection. And then also in that list that that document you're gonna forward, is there like a list of who he should contact first? Because I put together like a simple document, like, disconnect the internet, cancel the TV service, stuff like that. But I think it would be very wise to have a list of who he should contact first and maybe at what point. So I guess I have like 3 questions in there.
So assuming we have to contact somebody, among the 3 people on this panel, if you worked with Bertha, you would contact Bertha first, because she's the one that's gonna help you get your spouse actually, what's the appropriate way, finished up. Yes, yes. So she would be first. Troy would probably be second, because if he's managing your investments, he's gonna be able to talk to you about your income streams. And then I would be third, because the timelines in my world are not as pressing as the timelines probably in their world. So that's question 1. Question 2, you're fine on your safe deposit box. I'm not, as long as he's around and everybody knows, but sometimes you get these situations where the individual is the only named person on the box, and then nobody else can get to it, and they literally have to, there's a whole section of the estates code designated getting an emergency order to get into a safe deposit box. And then a lot of times it becomes like when Geraldo opened Al Capone's vault. There's all this to do, and they wheel the thing out there, you open, there's nothing in it, or like a wood nickel or something. So anyway, we're just trying to make things as easy as possible. And then I forget what the other one was. Your power, you mentioned something about your power of attorney.
Yeah, with the power of attorney, would I have listed that when I made my will and trust? It was a few years ago and I haven't looked at it, so.
Would you have listed whether or not you had one, or would you have listed who your decision makers were?
Who?
You would have, and it would be in a separate document, usually called statutory durable power of attorney.
Okay.
There's a whole bunch of boilerplate that goes along with it. It's like you need a law license to read it.
Okay, thank you.
Do you want to add to that?
Like Lorne said earlier, you have 4 years to probate the will, right? But we like to tell our clients we're usually the 3rd phone call. Most people think like maybe the priest or the pastor is going to be like the 3rd phone call, but we usually say that decision's already made. That's kind of a joke. But but when we want to be the trusted advisor, the loyal trusted advisor, the quarterback. I mean, people call me all the time. Hey, you got to get a mortgage guy, get a hold of. Hey, you know, an estate planning attorney that needs to. I really don't know what to do. I just know that I have a will, or I don't have a will, or I need to get it updated, because every few years there's usually some tax changes or some estate planning or law changes. So that's all I really add to that. Is really just, if you have somebody in your corner, a trusted advisor, it really, really goes a long way. I know a lot of times people think that they can somehow escape the system, but it really, really does help to have those people in your corner.
Anybody else?
Can I ask a question for Bertha?
Yeah, absolutely.
how long does it typically take a person to finish paying for their pre-planning plan? Is it like 5 years, 10 years? Do they decide the monthly payment kind of thing?
So the question that's asked is, how long does it take to pay for a pre-plan? It depends on what you have. You know, like say for instance, a direct cremation, you know, is going to take a lot less time than maybe paying for a traditional service. I mean, you still have 3 years, 5 years, some instances, 10 years to pay for it. But again, we can tailor make it for you. So I've had clients that say, Bertha, I have $150. That's all I have. I need you to help me to start something. And I get you into that $150 bucket. You know, if you have a direct cremation, you know, you can pay for a direct cremation $50 a month, I'm just saying, you know. So it just depends on what you want and the things you choose. And remember, my services are free to sit down with you, whether it's on a WebEx or, you know, virtually or in one of our locations. It won't cost you anything. And I tell people that's the biggest thing, is just reach out and get the information. That's the most important thing you want to do, is get the information, because we know that 2 things are going to happen. You're going to plan someone's service, or someone is going to plan your service.
One more question, then we're going to do our drawing. Anybody else? All right.
I have a question.
Okay.
What happens if, when all this happens and your attorney is no longer practicing law, what's the best thing to do in that case?
Find a new attorney.
That's what I thought.
Yep, and it's happening more and more. In some ways, I wish there were more young people practicing space. In other ways, I'm really glad it's not. Because it's a great way to serve people in their time of need. But if you're headed to the probate court system for one reason or another, and normally the reason that you are is to get a deceased spouse's name off the title to your home, then you're going to have to utilize the services of a licensed attorney. That's just the way the law is, because you are asking to represent an estate, which in itself is a separate legal entity, and just the law won't allow you to do that. So, but yes, you would have to retain the services of a new attorney. I would say this though, when that takes place, whoever you choose, ask them for flat fees so that you know what the cost is going to be. It is very common in the probate industry to charge clients a flat fee rather than an hourly fee. Give an attorney who wants to take a retainer and bill it by the hour on an uncontested matter. In other words, nobody's fighting, everything's fairly straightforward. I would avoid that. I would ask the attorney for a flat fee basis so you know what the cost is.
I think that's good. I really haven't heard it described like that, but I think there's a lot of people that are hesitant and want to get around probate if they can, just because it's so, they think it's so costly.
Yeah, and in Texas, it's really not. Now, if we have clients that are moving here from California and they're scared to death of probate, and they should be, because in California, the attorney's fees are set as a percentage of the overall value of the estate. That's a total difference from what Texas had. Texas is all about the independence of the individual. We want you to go to court one time, get the appointment that you need, and then go and live your life and settle this estate without a whole lot of court involvement. And that's the system's designed that way. And it really makes Texas unique in probate practice.
Ask.
I got a question.
Okay, go ahead.
Go ahead. Is there a value of an estate in Texas that does not need to be probated?
Not necessarily, but there are values that do not require the full-fledged, what we would call independent administration. For example, an estate of $75,000 or less can go through a heirship affidavit or a small estate affidavit process, which does not require the hearing, does not require the follow-up reporting that an independent administration does. And that's usually $75,000, not counting a homestead. And so there are certain states out there that qualify for that. And even if you need an attorney, you're going to get that at a lower rate than you would get full-fledged administration.
Okay, well, we want to thank everybody for coming today. Thank you so much for being a part of this. Our next seminar is May 13th. May 13th. The topic is
Senior living options.
Senior living options. That's going to be an important one. Now, we have two different senior living options. That one's going to be senior living options for lease, correct?
Yes.
Okay, that's May 13th. And then in June, we will have senior living options for purchase. And that one, we're going to go and visit the Magnolia Center here at the Meridian. We're real excited. We didn't get to do that last year. Our experts are around for those of you that are present in case you have a couple of more questions. In the meantime, we'll be sending out the notes for you, as well as ways that you can contact Lorne, Bertha, or Troy. Thanks, Bunch.